Thanks very much. Just to say a few words of introduction. My name is Lyal Sunga, and I'm a Canadian national. It's a real pleasure for me to come to the Rhodes Forum and hear people's views on some of the most important issues in international relations that are in front of us. My background is I'm a visiting professor at the Royal Wallenberg Institute for Human Rights and Humanitarian Law in Sweden, and also special advisor on human rights and humanitarian law at the International Development Law Organization, and actually live in Rome, Italy. My background is both academic and practical in the sense that I've been working a lot in international criminal law, international humanitarian law, human rights, and also working with the United Nations. Sometime back in 1994, I was responsible for investigating the genocide and associated violations with the Security Council's Commission of Experts on Rwanda that was formed by Boutros Boutros-Ghali on July 1st, 1994. So I was in support of that body, which was quite an interesting experience, very shocking. And I had occasion to share some of the experience today with participants because international criminal law is a very rapidly growing area. It's something that's very controversial, but I hope I could share some of the insights that I've had over the years, my personal experiences as well, having been in Rwanda so soon after the violations, after the genocide. And so it's a pleasure to do that. So, yeah. It's often been postulated that criminal law and human rights are really internal affairs. And there's Article 2.7 of the United Nations Charter, which says nothing in the present charter shall authorize any state to interfere in or the organization to interfere in matters essentially within domestic jurisdiction. Now, at the same time, the United Nations Charter, also in Articles 55 and 56, and then also Article 1, Paragraph 3, put human rights very high on the international agenda, so that, when somebody is being tortured, or there is a genocide, or there's slavery, or any of the other kinds of violations, it is not something which is entirely a domestic matter anymore. We cannot say, that's your own business, and to the government of the member states, intervention goes that far. I mean, every country has violations, but there are some violations that are so severe that international intervention of some sort is important, and it's necessary. And the question is, what kind of intervention? And one has to make sure that the intervention itself, the medicine is not worse than the cure. And humanitarian intervention, which is the topic that I addressed today, is very suspect. And many presenters said, well, there should never be a humanitarian intervention. The problem with that view is, first of all, we have to be very clear what it means, humanitarian intervention. And in my presentation, I was also saying that unilateral intervention, when we're talking about humanitarian intervention, we're talking about military intervention in the territory of another state without that state's consent to protect the nationals of that other state against its own government. So it's not for the intervening state that's protecting its own nationals. It is not a situation of humanitarian assistance in terms of food drops or vaccination campaigns, things like that. We're talking about military intervention to stop, for example, a genocide against foreign nationals by the government, violating its own citizens' rights. Now, the problem with humanitarian intervention has been that countries are not normally extremely excited about sending their soldiers in harm's way and having the body bags come back and explaining to families, oh, well, we are doing a good deed for people we don't know. We don't have self-interest, and we don't have any geostrategic interests in some foreign country. It's very hard for a government to do that. And on the other hand, it's also dangerous for international peace and security and international law if every government on its own, unilaterally or perhaps jointly with others, decided on its own appreciation of the facts who's responsible for what, and then to use military intervention. This military intervention is a very serious thing. So if we look into the history of it, we find that it's been more abused than used properly. Used properly in the sense that it should be limited, should be proportional, should not be mixed up with political, economic, or other considerations of self-interest. And what we've seen instead is that even in the most compelling cases, the intervening states had some interest or other. For example, in India, intervening in Bangladesh in 1971, in the Bangladesh Liberation War, where East Pakistan was succeeding from Pakistan. And there had already been a huge number of atrocities. The United Nations Collective Security System, the Security Council, didn't take action. And we're talking about mass rape and murder and torture, men, women, and children. And India intervened. I'm glad they intervened. I mean, they intervened and they stopped the violence. They sought no territorial conquest. They left fairly quickly. That's one of the most clear cases of humanitarian intervention, one could argue. Unfortunately, even in that case, India had a very strong strategic interest to weaken Pakistan, which is its rival. Excuse me. And even India, the government of India, stated that its justification for humanitarian intervention actually was really self-defense. And it's hard then for other people to say, well, no, your justification was humanitarian intervention. It was humanitarian, stick with that. There's also an intervention by Tanzania to depose Idi Amin, who had already killed between 300,000 and 500,000 people in Uganda. And people cheered. And there's some good that came out of it. On the other hand, Tanzania also had its own self-interests to territorial and geostrategic. And even weaker cases, Vietnam intervened to stop the Khmer Rouge. And again, there were good things that came from that because, perhaps 3 to 4 million or 2 to 3 million had been killed in Cambodia during these perilous years between 1975 and 1979 of the Khmer Rouge regime. But Vietnam, if it had been acting on a humanitarian basis, should have acted much earlier than it did instead of 1979. It waited a long time. Number two, it hung around in Cambodian territory and showed no inclination to leave until the Soviet Union pushed it out or pressured it to leave. And thirdly, the government itself said, well, we're not really doing it for humanitarian reasons, it's also for self-defense. So, and if we look even further in history, we see that there's always these self-interests mixed up with humanitarian motives or stated humanitarian motives. So it's what I'd like to see, and I mentioned Rwanda. It was very shocking what I saw there. My job was to journey through the country by helicopter and by Rhodes, and to visit massacre sites with a Spanish forensic team. And I saw the most horrific scenes. I mean, babies, slaughtered, pregnant women, men, infants, children, women, everybody massacred. And what was perhaps most disturbing was that they were not armed. They were defenseless civilians. And I saw massacre site after massacre site. People in churches, schools, other places where they had, in earlier times of strife, felt safe. and instead were kind of shepherded there by the Radio Mille Collines broadcasts, which said, we're going to get the Tutsis, we're going to get the Tutsis, attack the cockroaches, the Inyenzi they called them. And so once they went there, and they knew they would go there, there was a very clearly pre-planned, systematic slaughter. And that's why when we went there, we didn't see, combat deaths, soldiers, militia, fallen in battle of some sort. We saw civilians massacred by the hundreds. And I was thinking when I was there, I was thought, unilateral humanitarian intervention I know is risky. I would have loved if another country had come in. But better would have been what the world is supposed to have and what is spelt out in the Charter of the United Nations, which is a system of collective security to protect everyone from major breaches and to in case of a breach or threat to international peace and security, under Article 39 of the UN Charter, backed up also by the powers to impose sanctions and take military action, the Articles 41 and 42. The United Nations is supposed to act. Problem is, we know that since the long Cold War years, and we may be slipping into some Cold War, there have been the big countries, P5 countries, permanent 5 member states, that have cast a veto here or there for their own self-interests. So, I'm very proud to have been involved in the investigation of Rwanda and to be involved in the early stages of the setting up of the International Criminal Tribunal for Rwanda. But at the same time, it was difficult for me. I was, much younger then too. But to go there and to know that that was the United Nations' greatest shame, because the United Nations had entirely failed to stop the genocide. But it's not just the United Nations' fault. The United Nations can only do what member states will allow it to do. And Kofi Annan was head of peacekeeping at the time, and and I have a great admiration for him. I think he's one of our best Secretary Generals. And to his credit, afterwards he said, we failed miserably, and we have to develop a responsibility to protect doctrine, and he initiated a whole process to do that. And so there are a lot of questions out there. I've heard a lot of criticisms of international criminal law and justice, and I've been a critic myself, but at the same time I've been an advocate of holding individuals responsible for the decisions of this kind that they take. Now, if you can murder somebody on the streets in any country and be held criminally responsible, shouldn't you be held criminally responsible somehow if you're responsible for 1 million deaths? And the problem is, this is where international criminal law and justice comes in. Problem is that, for example, in Rwanda, the Hutu militia that planned and executed this huge massacre in a very systematic and premeditated fashion. That's what we found when we were there, after collecting a huge amount of information and witnesses and massacre sites and documents and etc., interviews. They had deliberately targeted the domestic court system and wiped out 80% of judges and lawyers, so that in case they lost power, which they did, thanks to Paul Kagame's armies and the RPF, there wouldn't be prosecutions. So what do you do in such a case? If you don't have criminal justice at the domestic level when you most sorely need it, and there are criminals running around, can you have impunity? You must not have impunity. You must have some other means. That's why the Security Council took the very extraordinary action, following the model of the ICTY, the International Criminal Tribunal for the former Yugoslavia, the year before, in May 1993, established the ICTY because domestic avenues were blocked, either because the state was unwilling or unable to act. And so And the number of deaths probably much fewer in former Yugoslavia than what happened in Rwanda. Would have been patently discriminatory if we said, oh, poor little Rwanda. Former Yugoslavia is on the doorstep of Europe, you know, it's part of Europe. We set up a tribunal there, but we don't do anything for Rwanda. Victims need justice, the victim's family needs justice. But it's more than that. Society itself cannot escape from the trap of blaming the other side in its totality. You know, when somebody comes to a village, whether in Bosnia-Herzegovina or Croatia or Serbia, they don't say it was this or that soldier or commander who committed the violations. They say it was the Serbs or the Bosnians or whomever. And they teach the children, this is what happened in our village. Responsibility in that popular imagination, because of the great amount of hurt, in some way is collective. And it's perhaps normal. Same thing happened after India-Pakistan. There were violations in 1947, on August 15th, you know, when there was a partition. People said it was the Muslims. People said it was the Hindus. People said it was the Sikhs. What international criminal law and justice can do is individualize responsibilities and say, we don't care where you're from or what your motives were, you carried out these violations. And you have to be individually responsible, no matter how high your official rank or capacity, whether you're head of state or a common soldier or maybe a private citizen. But if domestic avenues, which is where criminal law should be effective, and 99.999% of cases are prosecuted after all by domestic courts of concern to the local communities in the state, if they don't operate, you can't just have impunity. So that's why I've been advocating international criminal law and justice and human rights, and why it has to be seen as a universal phenomenon. And it's not good enough to have ad hoc courts, because then you have to marshal the political will every time, which may only come about once the major part of violations have already been perpetrated. So that's rather retrospective, ex post facto, after the fact. Wouldn't it be better to have a permanent international criminal court that stands and sends a symbol that, you know, leaders and perpetrators who are contemplating these things may be held accountable? And that's the concept behind the International Criminal Court. It's to not jump in every time there's a car theft. It's to look at the situations that are of, you know, crimes of the greatest international concern, and with respect to guarding international peace and security, and in terms of victims, to allow victims to be you know, have some measure of justice, and for communities to heal. So that's about transitional justice and international criminal law and justice.